like to call us to order, please. Meeting of the Procedure and House Affairs. I'll let the members, or remind the members, we are televised and in public today, but we have a little bit of committee business to finish. When we last left you, seems so long ago when I left all my friends, we were on the amendment by Madame Latendresse, and our speaking list included Mr. Lamoureux was still speaking to the amendment, or to the motion, sorry, to the motion, and then I had others on the speaking list. So, Mr. Lamoureux?
Yeah, Mr. Chair, I suspect because we have limited time this morning that I would like to see us defer this discussion until after we've heard from the presenters at the very least.
Agreed.
All right. I'll have to go down the list. Mr. Lukiski?
No problem.
Fine. And Mr. Christofferson, you're on the list also, but we'll defer that list in the way it is until such time as it gets brought up again. Thank you very much. Mr. Saunders, good to have you here this morning. And you have an opening statement for us, if you would. Well, then let's go ahead and go to that, and we'll get to questions.
Okay. Thank you for the invitation to appear before you today as you continue your consideration of Bill C-23. I provided all members of the committee, through the clerk, with a brief overview of the Office of the Director of Public Prosecutions. I do not propose to take up the committee's time by going over this background information now. I'll get right to the matter at hand. The only proposal in Bill C-23 that affects the Public Prosecution Service of Canada is the transfer of the position of Commissioner of Canada Elections and of the Commissioner's staff to the PPSC. While I have concerns in respect of certain aspects of the proposed transfer, I believe that it could be made without affecting the PPSC's ability to carry out its prosecution function independently of the investigative work carried out by the Commissioner. I say this for three reasons. First, prosecutors are bound to respect the constitutional principle of prosecutorial independence. This means we must make our decisions to initiate or continue a prosecution independently. This fundamental principle is ingrained in and followed by all prosecutors. It is part of the culture of prosecutors and will continue to be respected by prosecutors. Ensuite, les fonctions d'enquête et de poursuite demeurent séparées.
Second, Bill C-23 keeps the investigative and prosecutorial functions separate. The bill does not in any way give the DPP the authority to conduct investigations under the Canada Elections Act. In fact, the bill is clear that the Commissioner alone has that authority and that he or she is to conduct the investigations independently of the DPP. Therefore, prosecutors would not be able to initiate or direct an investigation. While prosecutors would be able to provide advice to the Commissioner during an investigation, they would only do so if the Commissioner asks.
Be housed in the PPSC, and the employees who work for him would become PPSC employees. The Commissioner and his employees would form a separate and autonomous unit within the PPSC. The Commissioner, not the DPP, is identified as the deputy head of this unit for purposes of hiring staff and for managing all human resources. Let me now turn to the concerns I have with respect to two aspects of the proposed transfer. The concern flow from provisions in the bill that might create the perception that the DPP is too close to the investigative function to conduct the prosecution function independently. The bill proposes that the DPP have the authority to hire the Commissioner and to dismiss him or her for cause. This authority could be seen as giving the DPP a degree of control over the investigative function. Another concern relates to the payment of investigative expenses. The bill provides that expenses incurred by the Commissioner shall be paid out of the Consolidated Revenue Fund on the certificate of the DPP. This authority may also give rise to a perception that the DPP has a degree of control over investigations. These two concerns must be viewed, however, in the context of the safeguards of prosecutorial independence I mentioned at the outset, and against administrative measures that could be put in place to enhance the separation of the two functions. So viewed, I believe that the perception of prosecutorial independence would mirror the reality of that independence. Finally, I should note that I also had a concern with respect to the original proposal in Bill C-23 regarding the annual report. The proposal was to amend the DPP Act and require the DPP to report on the activities of the Commissioner. This may have created a perception problem similar to the ones I've mentioned just now. Among the proposed changes to Bill C-23 announced last Friday is one that would address this concern. Under it, the Commissioner of Canada Elections would prepare his or her own report. I have no comments on the other measures proposed in the bill, as they do not affect the PPSC's operations. Thank you. I'd be pleased to answer your questions.
Well, thank you very much. We will go to 7-round questions. Mr. Lukiski, you're first, please.
Thank you very much, and thank you, Mr. Saunders, for being here. Thank you for your opening statement. Just to be clear, I just want to make sure we set the table here. Under the proposed legislation, as was the case with the former legislation, only the Commissioner of Elections can determine whether or not he wishes to recommend to your office that prosecution be engaged. Is that correct?
That is correct.
But you make the final decision? In other words, if a recommendation was forthcoming from the Commissioner of Elections, could your office examine the recommendation and then determine not to proceed?
That is correct.
That has always been the case. That remains the case under the new legislation?
That's always been the case, and that is the case, I might add, for all all investigations under any legislation.
The reason I wanted to clarify that is because you had mentioned that you had some concerns in a couple of different areas of the perception.
Yes.
If, however, it is clear in the legislation, both the current legislation and the proposed legislation, that the authority and decision to proceed is yours and yours alone, would that not go a long way in clearing up any misconception about the independence of both your office and that of the Commissioner of Elections?
As I mentioned in the opening, I'm satisfied that on balance, an informed person looking at the entire bill and at the measures we can introduce, realistically and practically would conclude that the perception is very low. However, the perception is something that's important to me, in that it's important to maintain the confidence of the public in the administration of justice. So it's not only necessary that I be seen or that I act independently, but also that I be seen as acting independently. The hiring and firing provisions caused me some concern at the outset, because it might be perceived that if I'm hiring the person who's to be the commissioner, when it comes time for me to assess the results of that person's investigation in a fair, objective, and independent fashion, someone might say, well, you're going to favor someone who you've hired. Likewise, when it comes to the firing power, there might be a perception in some that if I can fire for cause, which would include the ability to fire for incompetence, I have some power to, in a sense, oversee the type of quality of investigations. Now, when you take these and measure them against the safeguards I mentioned at the outset, I believe this perception is not well-founded. But nevertheless, I thought this committee should be aware that there is a possibility that some might have this perception.
And I appreciate your candor, but again, let's be clear. That is only perception, and you say the threshold of that perception is probably pretty low. Your appearance here today, I think, will go a long way to assuring Canadians that who might have had that perception that there really, truly will be continued independence, both your office and the Commissioner of Elections. Let me just try and hone in on something you just mentioned, and that is on the ability to dismiss the Commissioner of Elections with cause. You mentioned incompetence. Well, obviously, and I suppose in almost any job, if you were to dismiss someone based on incompetence, that would be considered to be fair and a normal proceeding. But wouldn't the threshold to try and prove incompetence be extremely high in this case? Because the legislation proposes that the Commissioner of Election be hired for a 7-year term and can only be dismissed with cause. The intent of the legislation is to assure Canadians and to, in fact, give the Commissioner of Elections a solid measure of independence without interference from any government. So could you explain exactly, in your mind, what the threshold of incompetence or cause for your termination would be? How egregious would the actions of the Commissioner of Elections have to be before he could be dismissed?
Let me give you a bit of background to that. For cause would include incompetence, conflict of interest, misconduct, misbehavior, things of that nature. The Act, or the project, probably on French, the projet, the bill also proposes or states that the Commissioner will conduct his investigations independently. So I won't have the ability to see what he's doing in respect to many investigations. I only get the investigations which he concludes have evidence to show reasonable grounds to believe an offense has been committed. They get referred to me. So for a portion of his work, the portion that results in compliance agreements, the portion that results in no conclusion that it should be referred to me, I don't get to oversee that at all. I never see it, unless one of our counsels provided advice during the course of the investigation. So when you ask me, when can I exercise the power to dismiss for cause, it would have to be in relation to cases that have been brought to our attention in which, for example, the investigation is not just gone totally off the rails, but has been an improper investigation in our estimation.
So wouldn't that even further strengthen the independence of the Commissioner of Elections? In other words, since you don't have the ability to see what he may be doing in his work that does not result in a recommendation to your office, would that not then be even further assurance that he has complete independence in his own affairs?
Yes, it would, but I just want the committee to realize that in giving me the power to dismiss for cause, I will not have the ability to oversee at all the work that the Commissioner does in respect of his investigations.
But that's my point.
Yes.
That's my point. Then therefore, his office is completely independent, because you do not see what he is doing in those investigations that don't result in a recommendation to prosecute. If you had the ability to observe or make comment on all of his investigations, even those that don't result in a recommendation to prosecute, one perhaps could then say that you have, your tentacles into his office. But by not seeing that and only seeing a small portion of what he does, that has to assure Canadians that he has complete independence, does it not?
The point of mine raising this is that someone could look at the statute and say the DPP has the authority to hire and dismiss the Commissioner for cause. That would suggest to many, or to some at least, that I have some power of oversight over how the investigation is conducted. Other provisions of the statute make it clear that I do not have authority over the investigations. Those are to be conducted independently of me.
So finally, again, how much time? Outside of the
Thank you, Mr. Lukiski. We'll go to Mr. Scott for 7 minutes, please.
Thank you, Mr. Chair, and thank you, Mr. Saunders, for coming. First few questions, I hope we can make them fairly short questions and answers. One is it usual for an investigative unit like the Commissioners to actually be physically and organizationally located in the office, the Director of Public Prosecution's ambit? Is that a normal thing to have an investigative unit, and how many are there?
This will be the first time in our experience that this is here.
Thank you. And this being the first time this has happened, were you consulted or involved in the decision-making on how that move should be structured?
No, I wasn't consulted.
Thank you. And are you aware of any report or ongoing discussion in sort of justice or enforcement circles where there was active recommendations from some quarter to move the Commissioner for Canada Elections to the office of the DPP?
No, I'm not.
Okay, thank you. In your 2012-13 annual report, you write, quote, "The PPSC, Public Prosecution Service of Canada, prosecutes charges of violating federal law laid following an investigation by a law enforcement agency. The PPSC is not an investigative agency, does not conduct investigations," and this relates to what we just talked about being unusual or unheard of, to have a unit within your office. "The separation of law enforcement from the prosecution function is a well-established principle of the Canadian criminal justice system," unquote. Now, I realize that's a functional statement.
Yes.
It doesn't necessarily mean that you have to be physically, on the other side of the city. So I'm not getting at that, but the functional separation is stated very clearly in your report. So given this statement, it would seem to me, anyway, that the movement of the Commissioner to your office and subsequent DPP's offices would need to have some kind of a special rationale or justification. And so I want to start with the first one, necessity. Is there anything about how you understand how the Commissioner has worked, including working with the Office of the Officer of Parliament, the Chief Electoral Officer, anything that you know that necessitates the move of the Commissioner to your office? Is it a necessary move?
I'm not in a position to answer that. It's a policy choice of the government, ultimately of Parliament, to decide where to place the Commissioner of Elections. My role in coming here today was to describe to you what operational impacts that move might have on the organization which I head.
Okay. then I presume you'd probably not be able to help me either with the next question, which another rationale would be whether or not the move is a positive benefit to investigations.
Again, that's a policy choice, and I'd also point out that in terms of investigations, we keep some distance from investigation. That becomes the responsibility. That is the responsibility, and will remain the responsibility of the Commissioner of Elections Canada.
So I just remind the committee that, and I appreciate the position you're in answering questions along these lines, that the previous commissioners, Commissioner Corbett and the current Commissioner Cote, gave quite detailed testimony on what would be lost by virtue of the separation, the organic separation. And subsequent questions will probably go into those, but I'm not sure you'll feel all that qualified to help in the answer. But it's important to know that just because you're doing your best or will be able to accommodate the move in no way is evidence that it's a necessary move. So here's something I think you probably can answer, which is you do note and that, of course, cooperation between investigators and prosecutors is essential, even though the functions are separate. So the question is, has the kind of cooperation that has occurred between the Commissioner and the DPP's office been hindered in any relevant way by the fact that the Commissioner's office is not within your office? Has it ever been hindered?
We've provided the same type of pre-charge advice to the Commissioner of Elections as we provide it to other regulatory agencies.
So the short answer, it sounds like at least nothing different than your relationship with any other law enforcement agency. Okay. So let me take you through three provisions, one of which you did mention, and just ask whether or not this is not going to be some kind of a hindrance on your relationship to the Commissioner. The first is in C-23, it expressly prohibits you from consulting with the Chief Electoral Officer with respect to an appointment of the Commissioner. And so any knowledge the Chief Electoral Officer may have, either with respect to criteria or candidates, would be blocked from your view. Are you willing or able to answer on whether such a ban is helpful to your ability to appoint the DPP?
I mean, again, that's a policy choice that's a policy choice that's being made by the government and ultimately by Parliament.
Well, hasn't yet been made by Parliament.
Well, that will have to be made by Parliament, as you've said.
The government certainly has. Yeah. Firing for cause, you've already indicated, and you've been very articulate in why perceptions matter in the administration of justice. Former Auditor General Fraser specifically talked about the perception problem as being real. So, and it has nothing to do with either you or future DPPs actually not being independent. But the dismissal procedure does allow for you to fire with cause. Would there be any problem if a policy choice were made to provide the same dismissal procedure for the Commissioner as, for example, now exists for the Chief Electoral Officer, which is that it's by the Governor General on a motion on the request of a joint request of the House and the Senate? Again,
you're asking me policy questions that are just beyond what I can comment on.
But there would be no problem if that power were taken away from you. You would have no problem with it.
I'll live with whatever powers the Parliament decides to give me.
Great. And here's one thing, though. You would have to be concerned about the quality of the pool that you have to draw from. The fact of the matter is that you would be prohibited from appointing anybody who has ever worked for Elections Canada, temporarily or permanently, ever, to the position of Commissioner. Would you say that that would narrow the pool?
Well, in terms of how this would take place, I indicated that we could put in place administrative measures to address. In terms of hiring, I think we would consider adopting a procedure where it would be very transparent, would be open, it would be a position that would be available for all Canadians to apply for, and presumably that there would be Canadians who work for other enforcement agencies, who work for provincial elections agency, who might be expressing interest in obtaining the position.
Thank you, Mr. Scott. We'll go to Mr. Lamoureux for 7 minutes, please.
Yes, thank you, Mr. Chair. Mr. Saunders, welcome to the committee. I want to pick up on the point that to the very best of your knowledge, you had no sense, no understanding, you were never consulted in any fashion prior to the introduction of Bill C-23. That's correct?
That is correct. I was not consulted.
Do you, when you look in terms of now what's being asked of your office to conduct, you emphasize how important it is that we take into consideration the issue of perception. You made reference to the whole hiring and dismissing. How would you suggest to the committee that that specific aspect be best dealt with? How do you plan, if this legislation was to pass unamended, to hire a future commissioner?
Well, I indicated in response to a previous question that we're at the early stages of considering how best to address this bill. But one proposal would be that we conduct a national open competition where Canadians with the experience in enforcement elections could apply, and a board of selection could be struck to consider the candidates and select the candidate who best meets the criteria.
Right. Do you, in terms of dismissing, do you have anything that you'd like to add to the idea of what it would take for you to be able to dismiss?
No, but in terms of dismissing, again, our preliminary thinking is that we would, if we had concerns emerging from what we see in respect to the work of the Commissioner of Elections, we could retain a respected outside authority to examine our concerns, prepare a report, make our decision based upon that report, and to be transparent with Canadians by giving a public statement if our decision was to dismiss the Commissioner, or in fact, if it was something that was publicly known, to retain the Commissioner.
The current process of hiring and dismissal, I'm, for one, am not all that familiar with, I must say, but I'm wondering if you could give any indication whether or not you find that it's adequate, inadequate.
The existing one?
The existing one.
I'm not familiar enough with the existing procedure to be able to answer that question.
Right. When you take a look at the current commissioner, the elect CEO, the previous CEO, or I should say the former CEO, everyone seemed to be of the opinion that the commissioner should stay within Elections Canada. I was really taken aback when the commissioner himself, in his presentation, made it very clear that he feels completely independent, has absolutely no problems whatsoever in terms of being able to deal with the issues that he believes are important to Canadians in order to be able to deal with. What value is your office going to be able to provide the commissioner that he currently doesn't have today?
We will continue to respect the independence of the investigative function.
Yeah.
And we respect it now, and we will respect it if this bill is passed.
But is there anything specific that you can think of that is going to empower our commissioner to be able to do anything at all differently through your office versus Elections Canada's office?
No, I'm not familiar with all the aspects of the bill. I have focused on those provisions that have touched upon our operations. So I don't know if there's something in the bill that enhances his powers, his being the Commissioner of Elections.
My understanding was that when we had the commission originally set up, and I believe it was during the 70s, that it was actually outside of Elections Canada, and then it was brought into Elections Canada. Felt that that's where it is best held. Are you able to provide any sort of an insight or an opinion or a thought?
No, I'm not familiar with the history of the establishment of the Office of the Commissioner of Elections Canada, and I just know that when we were established in December of 2006, we were given authority, or the DPP was given authority, to initiate prosecutions under the Canada Elections Act. That was the new authority for us.
Right. You emphasized the importance of perception and how important that issue is in terms of public confidence. Do you believe having elections or the commissioner working out of your office is going to enhance the public perception of independence of the commissioner?
Well, in my opening, I gave the protections on this, which I think continue to exist, pardon me, which the bill proposes, and the other protections which will continue to exist. I mentioned that the law, or the bill makes it very clear that the Commissioner is to conduct his investigations independently of the DPP. We have our principle of prosecutorial independence, which is part of our culture, reflected in all our policy documents, which I might add also indicate that we should respect the independence of investigators. So in my mind, though there is the potential for a perception problem, when you look at the entire package, a well-informed person looking at this realistically and practically and thinking the matter through, that's the test for whether there is a perception problem, would conclude that we will be able to fulfill our prosecutorial function independently of the investigative influence.
Now, if the Commissioner wants to be able to investigate something such as a future robocall or something of that nature, any sort of needs for financing, would he have to or be obligated to go through you, Mr. Saunders, or your department? How does he get funneled that resources?
He has, under one of the provisions of the bill, he has in fact, direct access to consolidated revenue fund for certain resources he requires. The requirement that's imposed on the DPP by the bill would be that the DPP certify that the expense is appropriate. Now, that gave rise to the perception problem I mentioned earlier. That could be seen as giving the DPP some control over the investigations. But when you read that clause in conjunction with the clause that says that the Commissioner is to conduct his investigations independently, that leads me to conclude that my role in certifying is simply to say, is that expense, was it incurred in relation to an investigation? My role is not to examine whether it was a worthwhile expense incurred in the course of the investigation, but only was it incurred in the course of the investigation. Because it's up to him to conduct his investigation, which means he has to decide how to investigate, who to investigate, and what charges to investigate for. That's not the role of the DPP.
If he's got the money for it.
Pardon
Very
me?
much.
Okay.
We'll go to Mr. O'Toole. Good to see you.
Thank you, Mr. Chair. It's good to see you as well. I missed most of the committee, although Mr. Scott and I had good fortune to see a lot of each other over the break. Maybe good for me, not for him. Mr. Saunders, thank you for appearing, and I think one of the benefits of this televised proceeding is a lot of Canadians will understand better what the Director of Public Prosecutions and the Public Prosecution Service of Canada does. In many ways, you're the federal prosecutor dealing with fisheries, environment, transport, finance, a range of issues. For some provinces, prosecutions with respect to controlled drugs. So would it be fair to describe the overall department as a federal prosecutor?
Yes.
Since 2006-2007, you were given another area of prosecutorial jurisdiction with respect to election law, and you mentioned that to Mr. Lamoureux. So yet another area of federal jurisdiction for prosecution under your department. Since 2007, has the Attorney General interfered in any of the prosecutions related to election offenses?
No, he has not.
So
let me elaborate. As I point out in the background document that I provided to the committee, under the Director of Public Prosecutions Act, the Attorney General does not have the authority to issue any directives in respect of Elections Act prosecutions, nor am I required to provide him with notice of Elections Act prosecutions, and nor do I include reference to Elections Act prosecutions in the annual report that is provided to Parliament through the Attorney General.
So the concerns expressed by some with respect to that technical reporting nature is not a serious concern in your opinion?
Under the proposal that was made last Friday, the Commissioner of Elections will report separately on the activities of his office. He will attach that report to my report, but it will not be something I'll be reporting on.
You talked about perception in some detail during your opening statement and some of the responses to my colleagues. And you raised a few areas where you were concerned about the perception in a similar way to conflict of interest, that they could be real or perceived, and you were concerned about some perceptions. Is perception itself not a bigger issue when the investigation and prosecution services are housed within a specialized agency. So within the very agency, they're looking back to investigate, while part of that agency is looking forward on the administration.
The difficult would be if the function, the prosecution function and the investigative function were vested in the same person.
So 2006, prior to the changes in 2007 by our government, those features were housed in the same person, were they not? The investigation and prosecution.
I only know what I read, and I think I read the testimony of one witness who mentioned that was the case.
So in 2006, those functions were separated, the investigations from prosecutions. And now with the Fair Elections Act, the investigations, which will remain separate, are now going to be housed within the specialized federal prosecutors' offices, but as you said, are distinct within that. Would it not be fair to say that the changes from 2006 to today actually get at the root of eliminating perception issues?
They don't eliminate the perception problems that I mentioned, but look at my testimony as a whole. The perception problems I mentioned are ones that could arise, and my conclusion is that they can be addressed by the safeguards in the statute and administrative measures we could take. In terms of what existed before 2006, as I say, I only know what I read in terms of the testimony. I'm not really in a position to comment on.
Thank you very much.
We're going to go to Madame Latendresse.
Oui, merci.
4 minutes, please.
Oui, je vais donner une partie.
Thank you. I will be sharing my time with Mr. Christofferson. Thank you, Mr. Saunders, for being here today and for being able to speak with us about these changes. So to begin with, I'd like to come back to some things that have already been raised, but that I really wanted to emphasize. And I also wanted to ask you the question in French, it being my mother tongue. Could you please confirm that you were not consulted on the changes that are going to affect your department? That's correct. And did you read the Commissioner's report when the Commissioner appeared before the committee to discuss those changes? I read his testimony, but not the report. Has the report actually been tabled? Actually, I meant Mr. Côté's testimony, because I wanted to come back to some of Mr. Côté's quotes. When he appeared before committee, he said, in my opinion, if we separate the Commissioner from Elections Canada, there may be a gap between the administration of the rules and their enforcement. It is crucial to protect a continuous relationship between these two entities. He talks a great deal about this gap, and the CEO mentioned it as well, Chief Electoral Officer. When the Commissioner came to speak with us about this, I could see quite a major problem, because even though the Commissioner assured us that he himself is currently completely independent under the Canada Elections Act, he had major concerns about this. Do you share the Commissioner's concerns and the Chief Electoral Officer's concerns in this respect about the links between the Commissioner and yes? Well, that is a question that you'd have to ask Mr. Côté, because all I can talk to you about that's about investigations, and I can only talk to you about prosecutions. Well, do you not think, though, with that, given that type of comments and the way he explained it to us and presented it to us, would be sufficient to justify asking why it is that this transfer is being proposed now? Because many people believe it's not that it poses a huge problem or that it's necessarily a very negative change, but people are wondering why the change is necessary in the first place, if it doesn't truly change or affect the Commissioner's independence. Well, as I was saying earlier, this is a policy question that must be asked of the government, and it's a political issue that Parliament must decide. I'm here to discuss the impacts that such a change might have on the PPSC. Thank you very much. I will share the remainder of my time with Mr. Christofferson.
Thank you very much, Chair. Thank you very much for being here, sir. Again, you were not consulted at all. about this change.
That's right.
So the chief electoral officer and the previous one was not consulted, the elections commissioner was not consulted, and the previous one, and now we're making a major structural change, and the person that's the head of that department was also not consulted. Let's underscore the fact that the only people that were consulted on this bill and had input were card-carrying members of the Conservative Party. If you didn't belong to the Conservative Party, you got no input into this law, and here's further evidence. Who is your immediate boss, sir?
Well, pursuant to the Director of Public Prosecution Act, I conduct prosecutions under and behalf of the Attorney General.
But effectively, you're a deputy minister, correct?
I'm a deputy head, yes.
Yes, so your immediate boss is the minister. Is that fair?
Well, the parameters of the relationship between my office and the Attorney General's office are set out in the Director.
Agreed, but in terms of reporting, sir, I'm tight on time. That's why I'm being a little curt. I apologize. But it just effectively, for reporting purposes, the Attorney General is your reporting boss.
Yes, but reporting that I do is different from reporting that you will find in other departments.
How about the CEO? Who's his boss? Parliament. So there's the problem. We're moving from somebody, the elections commissioner is going to move from a current position where the person who holds that position, their boss, is accountable to all of Parliament, and we're moving it into a position where their boss is one step away from the Attorney General, and they have all the power. That is a huge problem of perception. That's fine. It was rhetorical anyway. Thanks, Chair.
I got that. Okay. Mr. Lukiski?
That's advantage Steve notice.
Very much, Chair. Yeah, I just want to pick up a little bit on a misperception, unfortunately, the opposition seems to be trying to promote, and that is under the current situation that the Commissioner of Elections has complete independence, and that simply is not the case. I'm not going to ask you to comment on policy, but let me just point out for the benefit of the committee and those of you people that Canadians may be watching under the current system, Elections Canada can hire, fire, and direct the Commissioner of Elections of which investigations to pursue. And it's that latter part that shows, I believe, quite clearly that under the current system, the Commissioner of Elections does not have complete independence. If the CEO of Elections Canada can tell the Commissioner of Elections to pursue an investigation, then the Commissioner of Elections does not have complete independence. Under the current, or at least proposed, legislation, that ability of anyone to tell the Commissioner of Elections of which investigation to pursue is gone. The ability to conduct investigations will solely be determined by the Commissioner of Elections. Do you not agree that that demonstrates complete independence on the investigatory portion of the relationship between yourself and the Commissioner of Elections?
Well, without taking a position on the policy ramifications, let me say that under the proposed bill, the Commissioner will have the right to conduct his investigation independently of the DPP. I will not, and no one in my organization will have the authority to direct the Commissioner to conduct an investigation.
Thank you for supporting and underscoring my point. Although the opposition continues to say that under the current legislation, under the current system, the Commissioner of Election has complete independence, he does not. If someone can instruct the Commissioner of Elections of what investigations to pursue, that means someone else is pulling the strings. And we believe, and as indicated in the Fair Elections Act, that the Commissioner of Elections should have complete independence upon what investigations to pursue. So I thank you for agreeing with my assessment on that. Finally, sir, let me just ask you this. You mentioned before that you believe that the threshold of perception is fairly low. Do you not believe it be the most important consideration in legislation is the reality? In other words, you have indicated that the only difficulty you're bringing to the attention of this committee is one of perception. But in reality, there is a complete distinction, complete separation of authority between your office and the Commissioner of Elections, and there is complete independence.
The reality of the independence will be respected, though I hope I made it clear that perception is important to us. It's important to public confidence in the administration of justice, the perception that prosecutors exercise their independence, exercise their discretion independently of investigators is maintained.
Would you simply agree that the reality is more important than perception? I agree perception is important, but the reality is there is complete independence between your office and that of the Commissioner of Elections.
No, I have to disagree with that. I think the it's very important to maintain perception of independence of the prosecutorial function.
Mr. Chair, might there be any time for a quick question for me at the end of the round? Just checking.
If the group agrees, then that may be a chance.
Thank you.
I have I have a government slot right now. Anybody? I'll go to Mr. Christofferson.
Thanks. I want to follow up on where Mr. Lukiski was. The Commissioner of Elections Canada said, indeed, this is his quote, indeed, and when he spoke before this committee, indeed, I must stress that as Commissioner, I have enjoyed complete and unfettered independence with respect to the conduct of investigations and the choice of enforcement action, including the decision to refer a matter to the DPP, end quote. So unless the government can give us one example, one concrete example, that would justify making this move, we have every reason to be suspect as to why they're doing it. The fact remains that the Commissioner of Elections will have to, even if it's just checking off a box, have to get the approval of somebody who is a deputy minister, accountable to a minister, which puts it into the political realm, in order to spend money. And everybody says, well, there's no problem. It'll just be a formality. There will be no judgment calls and everything. So my question would be, sir, would you see any problem then with an amendment that would allow the Commissioner of Elections to have direct access to the consolidated fund to spend money on investigations without having to get your interim step approval along the way?
I just want to clarify something. The Attorney General does not have authority in respect of elections matters under the Director of Public Prosecutions Act.
I understand, sir, but
that has not changed under the bill that's before you right now. And I'm not a deputy minister, I'm a deputy head. There is a distinction there because we're not a department of government, we're an agency. And in terms of your question...
Sorry, but that's no different than a deputy minister elsewhere.
Yes, it is, because my relationship differs from that of a deputy minister. My relationship is set out specifically in the...
So the point is you're not independent as the Chief Electoral Officer is my point, sir. The Chief Electoral Officer is independent of the government and answerable to Parliament, all of us. You, sir, are answerable to a politician at the end of the day.
That politician, though, is the Attorney General of Canada. You have to remember that when the Attorney General of Canada acts in the prosecution domain, he is bound by the same principles as I am. He is bound by the principle that he must exercise his discretion in a manner that is free of any partisan political motivation.
Agreed. But nonetheless, the change is being made, and there has to be a reason, and we have no example of a problem, so we have to wonder if the government prefers this kind of a system. And as the opposition, I'm pointing out that we now have a political line in the flow chart, whereas before we did not. But my specific question, sir, would you see any problem? Would you have any comments, thoughts on the idea that the Commissioner of Elections could access money from the Consolidated Revenue Fund without your okay or approval or involvement at all? Just direct access. Would you think that's okay? Your thoughts?
That's a question of policy for, again...
Is there a problem with it in terms of a procedure?
It wouldn't create operational problems for me.
So it wouldn't be any problem for you if there was a change in that. It doesn't affect the office in any way.
But at the end of the day, as I say, it's a policy decision that ultimately Parliament will have to make.
Okay. About 30 seconds.
We'll then refer back to the perception of this whole thing. I would ask you, what do you think would be lost if we left things the way they are? What would lose, like democracy, process? Tell me something that we would lose by virtue of going over to your office.
I'm not sure if I follow you. What would you lose by going over to my office?
Like what's being, yeah, I guess I worded that poorly. I acknowledge that. Okay. My concern is...
which now runs you out of time.
Okay.
No, it's about exercising it. Mr. O'Toole, your 4 minutes, please.
Thank you, Mr. Chair. Following that last exchange, there seemed to be some conflict between the testimony of Mr. Christofferson and testimony of Mr. Saunders. Then I realized you're the only one here actually giving testimony here today. So I'm going to review some of my last questions, potentially for Mr. Christofferson's benefit. The Attorney General, which we talked about in my first round, since 2007, you said there has been absolutely zero role or interference or by the Attorney General in the prosecution of election offences. Is that correct?
That's correct. By law, the Attorney General cannot interfere, if that's the word, or intervene in elections cases, and that has been respected.
So your department, Mr. Christopherson used the term the political line, the flow chart. Your agency is independent, and there is no operational flow chart. Is that correct? Like there is no role the Attorney General has in any of your prosecutions?
The only role that the Attorney General has in respect to prosecutions are the roles set out in the legislation itself, our legislation. That allows the Attorney General to issue a directive in respect of a particular case, if he so wishes. That allows the Attorney General to assume conduct of a prosecution. It also allows the Attorney General to intervene in a case. That's really a provincial prosecution,
Court, yeah.
or to issue a directive in respect to prosecutions generally. Each of these measures, if he takes them, has to be done in a transparent fashion. He has to publish, for example, any directive in respect of a case in the Canada Gazette. The idea being that transparency is an important protection of the independence and the protection of prosecutorial independence.
With respect to the budget, I'm sure every department in this fine city would love to have direct access and fund themselves, but that's generally not how things work. As the federal prosecutor, when your teams, be they fisheries or transportation, if there's prosecutions under those areas of federal jurisdiction and more funds are needed, more activity is happening, do they go through your agency for budgetary requests? Is that how it works currently?
No. We have a hybrid funding formula. Most of our funding is what's called A-base. We receive an appropriation from Parliament with respect to that funding. A very small amount is what we call cost recovery, where agencies will fund a prosecution, but we have agreements with these agencies to ensure that the mutual respect for the independence of the investigative function and that of the prosecutor function is maintained.
So in the reporting mechanisms, and you specified that the Commissioner will have a separate report within your report, or separate public report. If the Commissioner felt that more funds were needed because there was more investigations going on than the previous 5 years, is that something that he could put in his report to make sure that it was publicly available? Same with the rest of your department. If there were areas that were overtaxed, is that part of your annual report that you would talk about what areas are incurring more expenses, that sort of thing?
Our annual report is more on the activities of the previous year. We tend to make statements regarding our financial situation in the departmental performance report or the report on plans and priorities. Those are the documents you'll find statements of that nature.
Thank you. Those are my questions.
Thank you very much. That finishes our rounds of questioning today. We have a request from Ms. May for unanimous consent for one small question.
We have a few more minutes. Can we just ask questions until our time is?
Well, there would be the
after Ms. May, and then kick it. No, I wasn't going to stop you. One to Ms. May, and then just finish around the usual fashion until we're done.
Well, a round would be a government question, and then the other, and there wasn't enough time to do that if we're going to do that, and finish any of the committee business you deferred.
Short?
So,
well, we each take 2 minutes.
Mr. Christopherson?
2 minutes for Green, 2 minutes for Libs, 2 us, 2. We're done.
Yeah. I love it when we talk through the time we once had that would
we still have time,
done,
Chair. Go ahead.
But thank you. So we're at Ms. May's question first. Do I have consent for Ms. May to have one question?
Chair?
Yes?
Can I point out, and with all due respect to Ms. May, can we continue with the practice we've established before, and that is if one of the members of any political party who is recognized around this table wants to give up their question to Ms. May, they can certainly do so.
Let's not play games. Chair,
on that point of order, Mr.
On that point of order, yeah. I mean, we went out of our way to move a motion, trying to make sure that those who are also impacted this. I mean, the government just wants to keep it so tight as to who gets a say, and the fact remains that the independents represented by Ms. May have as much importance in this as anyone. We have time enough to do 2 minutes for 4 of us to do 2 rounds and be out of here with 2 minutes to spare. Stop playing games, please.
Jefferson, I am the chair, and I love the advice that you give me because I like how you chair also. But we don't have that time. We did defer at the start of the meeting some committee business on to here. So the question was asked, and you're right. In the past, in this committee, Mr. Lukiski is correct. Other times, a time has been given by somebody whose time it was. So it's not out of order to say that. Right? But I've asked.
Offering another opinion for you to consider.
Well, I did get that. Thank you. So do we have consent for Ms. May? No, I don't have it. So unanimous consent.
As I pointed out, if I may interject, if I pointed out, David, if you want to give up your time to Ms. May, please.
The government stepped in on a unanimous consent when we have time left to deny a member of Parliament representing the independents in our process a chance to ask a question. Shame on you. The official opposition will give our time to Ms. May.
Excellent. There we've got it settled.
One question, Ms. May, please go ahead.
First,
I knew we'd get there.
I want to thank the official opposition for doing that, but I want to reaffirm that the rights of every MP in this place are in principle equal, and that I do not speak here in committee solely when another party relinquishes its time. I have a right to speak if there is the decision of the chair, and it's the chair's discretion. My question, first of all, welcome.
But I will suggest that since it is the Procedure and House Affairs Committee, I will follow procedures.
Yes, I understand.
And so there's where we are.
You are a wonderful chair, and I love you. Now, may I just try to get whatever time is left? I love what I wanted to say.
Record on that last part?
Yes.
No,
En français disponible, c'est je t'aime. Okay.
This is available in French too.
Mr. Saunders, ironically, last time we saw each other, he was questioning me in a previous court matter. So what I wanted to do in clarifying your evidence here, which is very specific to your concern that this change in C-23 could place you as Director of Public Prosecutions in a situation of perceived conflict of interest, particularly around this issue of certification of appropriate expenses. As things now stand, the Chief Electoral Officer has direct access within budget to consolidated revenue funds without anyone having to certify. So I'd just like to ask you if you would agree with me that the status quo presents no difficulties for your office, and the status quo allows the Chief Electoral Officer to have access to previously approved budgetary funds without anyone else in a supervisory position having to certify the appropriateness of those expenses.
I take it that you're more familiar with the Act than I am. I'm not certain whether he can obtain funds without having anyone certify. I haven't read the existing Act close enough. I thought it was the Chief Electoral Officer who had to certify.
Yeah, Chief Electoral Officer is the one who gets to
certify that those expenses. If you ask, your question was simply, would it be less trouble for me if I didn't have this responsibility? Well, the answer is clearly is yes.
Thank you.
It's one less responsibility.
We'll stop our testimony there today. Thank you. And Mr. Saunders, thank you for coming today and sharing with us. Team, I just have a couple of questions of you. We had deferred the motion at the start of the meeting to later, deferred. Are we going back to it? Madame La Tendresse? You're not at that spot, but it is your motion, so I'll let you ask.
I'd like to know if we can have some clarification on the agenda for tomorrow, and if it would be able to, we would be able to.
Just brief us.
Yeah, at the beginning of before
Tomorrow. I have one other question. As we're going to be going into the clause by clause, but I'm trying to get all the evidentiary piece out. Okay, so that's, but Mr. Hahn, when he was here last week, he had tabled the document with us. It's a very large handwritten document, and it's only in English. And in order to dispense, to give it to the members, I'm told it can't be translated. I have to have unanimous consent in order for it to be distributed the way it is. Because it's a large handwritten poll clerk's handwritten notes, apparently. And very difficult for us to have a translator sit there and go through handwritten documents to translate.
You know, Chair, we run into these things all the time at all committees, and it always seems like a one-off, and those that are concerned, it causes a whittling and a whittling, but we want to make sure it's available. So is there a saw-off that maybe we could have it in the office of the clerk if anyone wants to see it, but not circulate? I'm really not comfortable with circulating documents that are not in both languages.
Any other further point on that one, Mr. Lukiski?
No, I don't have any issues with that. Although I would like to make comment in the couple of minutes we've got left about Ms. Letendres's motion by deferring it tomorrow. And I don't have a difficulty with deferring it to tomorrow, although since we're supposed to be starting clause-by-clause examination tomorrow, and I don't know how many clauses and amendments we've got.
Your chair's going to get to that in just a second.
My only caution would be I would not want to see lengthy debate on this motion tomorrow that cuts into the time of examination of the clause.
Okay.
If we can put a timeline on it.
Mr. Chair, point of order.
Point of order, Mr. Reid.
Just with regard to the document, I can imagine what it is. It's a handwritten document that was not intended for any such purpose as being submitted to the committee when it was done at the time. I appreciate Mr. Christopherson's concern about this being the thin edge of the wedge and more unilingual documents getting in here and so on. My question is, in the event that it's at the clerk's office, does it form a part of the permanent record of this committee, or is it effectively not going to be available to someone looking at the work of this committee?
Okay. Hang on, I need to ask that question. Same way. If it hasn't been distributed, no, it's not. It's just it's another brief that wasn't distributed, so it's not part of the evidence of this committee. So I need unanimous consent to distribute it or to not.
I would, well, I guess I'll go back to Mr. Hahn. I actually think that's a misinterpretation of that provision. Effectively, what happens is any document that's not translated effectively is unavailable to anybody ever permanently.
Right.
And that seems to me to be a departure from the long-standing practices. Somehow it's just crept in. I'd suggest that's an inappropriate interpretation. So I would hope that you would maybe go back and consult a little higher up and get back to us on that. Yeah, effectively making something a confidential document in perpetuity seems to be a meaningful problem.
Well, the clerk and I will discuss that and tell you tomorrow then. All right. Those were the two issues we had. There is some close to 300 amendments that we will be starting tomorrow, so I agree with what's been already said here. Let's not use up much of the time starting tomorrow on anything but that.
Just process, just to be sure I'm clear.
Yes.
The motion that was passed by the government said that Thursday at 5 o'clock we're done. And we have a 242-page bill roughly, and we have roughly 300 pages of amendment. Common sense would dictate that we're not likely to be finished by 5 o'clock. If we're not, is the government open to the idea that we can go beyond that so that we aren't limited in our discussion of the clauses and the amendments, realizing that there is an end date to all of this? But what we're setting ourselves up for, and correct me if I'm wrong, but if we're only on page 48 of 242 at 5 o'clock on Thursday, this process ends and the bill is taken from the committee and it reports back to the House and our work is over, whether or not we've actually done a detailed line-by-line process, which is what our job is, whether we've concluded that or not, the government motion deems that all debate is over at 5 o'clock on Thursday, and the bill is out of our hands. Do I have that right or wrong, sir?
Well, debate will end at 5 o'clock on Thursday. There would still be the voting on each.
But, yeah, right, but I'm talking about there'll be no further discussion, no further debate, no matter what clause we're on, no matter how far we are, we're just going to, it just stops.
Which tells you why it's important not to be using time on clause by clause.
Yeah, 2 minutes is going to matter in a 242-page bill with 300 pages of amendments. 3 minutes is really going to matter. This is more of the farce. This is more of the farce.
Mr.
242 pages, 300 pages of amendments, and we're going to have till 5 o'clock Friday, and we're not even meeting around the clock to do it. This is insane.
Well, some of the insanity was 2 or 3 days taken up with a filibuster, but I see it as 1 o'clock, so we will adjourn.